Next case.
Number 2, CEB 2020-10584 housing at 1046 East Michigan Street. We should have Brandon McDowell and Ava Harrett who are respondents for the case.
Yes, I have a Brandon McDowell in the attendees list.
Okay. Inspector Simmons' qualifications are on file. We're going to go ahead with the presentation.
The property in question is located at 1046 East Michigan Street, Unit 1050B, Orlando, Florida. This is near the intersection of St. Thomas Street. The property in question is in the 1000 Oaks neighborhood. It's owner occupied. The property is zoned R-3B. The property was first inspected on May 4th, 2020 for a housing violation as a result of a citizen's complaint. The date of the last inspection was Thursday, July 2nd, 2020. The notice of hearing was served by posting the property. At this time, let the record reflect that a copy of the compliance schedule was submitted to the representative of the property electronically. I'm requesting that the compliance schedule and photographs be accepted as submitted and incorporated into this record for this case.
So accepted.
The corrective action required for the outstanding violations is to provide an insect extermination for Unit 1050B. Treatment requires a licensed pest control company to perform the requirement or verification on a detailed Florida report that no live termite activity was found on inspection to alleviate treatment, and to provide documentation from a certified licensed structural engineer that the existing structural members are sound and capable of bearing imposed loads, including but not limited to beams, columns, corner posts, and load-bearing stud walls, or repair, replace, and paint where needed under permit pursuant to his or her recommendation and final improved inspection. I have been in communication with the property owner, the HOA, as well as I've spoken with some of the mechanical engineers here with the city, building inspectors. This is a major violation. It is a life safety issue. This floor has a possibility of caving in onto the unit below. This is an upstairs unit. There has been a change in management with the HOA, just a little background. So they are new HOA to this property, and there's several issues. They may be trying to alleviate some of these issues, but there's been a lot of back and forth between the owner of the unit and the HOA. The HOA is stating that the owner is not allowing access to the unit so that a structural engineer can come in. The owner of the unit has been doing all the correspondence through his attorney, which he was, I guess, advised attorney that you need to get with the HOA attorney. So I don't know what the back and forth is, but there hasn't been any resolution. So the city is requesting compliance within 30 days or by August 7th, 2020, or a penalty of $250 per day be imposed for non-compliance. In addition, I wanted to add that the gentleman took out his AC unit. He states that he does not have air conditioning right now, but he needs to replace the air conditioning unit, but he cannot replace it until the floors are repaired. It cannot be installed.
Officer Simmons, this is Alexa Garcia. So it's currently habitable? Someone's living in this unit in this condition?
Someone is living in this unit.
But yet you feel it's a life safety issue and it's not been condemned?
No, we have not condemned it.
Is this occupied by a tenant or the owner?
It's occupied by the owner. So it's like putting him out of his house during a pandemic. I don't know where he would go, but as you can notice from the pictures, as well as the inspectors here with the city, went out to his unit and did a little bit of assessment, and they felt that it was a life safety issue and that floor could possibly collapse.
Oh dear.
So who's the actual respondent in this case? Because $250 is quite a bit.
The respondent is the HOA.
Okay.
They're actually responsible for repairing the floors and the walls.
Right.
Okay.
So you say you've had communication with it. What is their plan? Are they planning on, how are they planning on fixing this?
Is she not on the line today? Is the
We
HOA?
have Brandon McDowell and Ava Harrod that can,
Well,
that's here for the case.
Eva is the HOA manager who I've been dealing with. If they want to speak on what their plan is, because as I stated, they are just communicating to me that they're not getting access to the unit. So sounds like they're trying to repair it, but I don't know why the property owner is not allowing access.
How did this case come into, who called this in? Was it the owner?
They're calling on each other. So the HOA called a complaint on him, and he called a complaint in on the HOA.
Okay, all right. Any other questions for the officer? All right, let's hear from the respondents. Thank you, officer.
Good morning. This is Attorney Brandon McDowell on behalf of 1000 Oaks.
Okay, Brandon, you need to be sworn in. Do you swear or affirm the evidence you give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You'll need to state your name, your mailing address, and your relationship to the property for the record.
For the record, Brandon McDowell, and I'm an attorney with Becker and Polkoff. We are counsel for the Association 1000 Oaks. Mailing address 111 North Orange Avenue, Suite 1400, Orlando 32801.
Okay, just so you're aware, your phone is cutting in and out pretty much every other word, so it's very difficult to hear you. I don't know if you're able to move to get some kind of better reception, but it is kind of difficult to understand everything you're saying.
My apologies for that. If need be, I can call back in as well. Is anyone able to understand me?
You're cutting off really bad.
I would recommend calling back in.
Okay, you could give
Or
me
calling in
30
from a
seconds. I will
landline phone.
disconnect and call back.
Okay.
All right, is Miss Eva on the line?
Yes, I am.
Okay, Miss Eva, you need to be sworn in. Do you swear or affirm the evidence you give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. If you could also state your name, your mailing address, and your relationship to the property for the record.
My name is Eva Harrod. My address is 243 Angeles Road in DeBerry, and I'm the CAM for this association.
All right, Miss Eva, can you give us, as far as what is your plan? How are we bringing this property into compliance?
Well, as the officer said, as the code enforcement officer said, I took management of this community back in November. I don't know if you were able to get all the presentation that the attorney sent for this case. I don't know if you got the paperwork or not. I've been trying to get in touch with first I was getting all the information from prior management company to see what was the status on this unit before me starting to calling vendors or engineers or contractors. Once I was informed of all the situation, I started contacting, we contact like 3 or 4 engineers to visit his unit. And I also met with Massey for the termites at his unit. And actually was the first time that he provide access to his unit by Massey.
Can anyone hear me?
Now we can.
Yeah.
This is Attorney McDowell again. Can everyone understand me clearly now?
We can hear you. Miss Eva is presenting real quick, if you don't mind standing by.
Understood. Thank you.
Thank you. Go ahead, Miss Eva.
Yeah, and then as the code enforcement is saying, we've been trying to contact people to go to his unit, but when the engineer and has been trying to contact him, he doesn't respond. So he responded to the engineer after he hired an attorney to tell him that he was no longer able to communicate with him directly and everything has to be through his attorney. So at that point, we had to hold off and wait until his attorney contact us.
And has that been done?
Yes.
Okay,
Well,
so we are,
the attorney is gonna say if he contact or not, because it's between the association's attorney and this attorney. So I don't know if he contact the attorney or not.
okay, all right, thank you, Ms. Eva. Mr. McDowell, can you give us a very brief synopsis of what the outcome has been so far? Have the respondent, well, not the respondent, has the property owner's attorney contacted you?
No, excuse me. No, they have not. So just briefly, because I did not get to hear Ms. Eva's full synopsis, really quickly, the association's insurance adjuster has been out and only the adjuster has been allowed entry into the unit. As far as the structural engineer, the association reached out, contacted multiple engineers to have someone come out and take a look at this issue. They found an engineer who was ready, willing, and able. He attempted contacting the owner on May 22nd and again on May 26th. On May 26th, the owner responded that he has now hired counsel and therefore he was not allowing entry, was my understanding of that communication. On May 27th, counsel for the owner sent in a request for the insurance policies. Following that, our office sent a letter to opposing counsel, to the owner's counsel, requesting dates and times specifically for entry with an engineer to look at the issues related to this matter, and all that communication has thus far gone unanswered.
Okay. All right, so the city currently is requesting only 30 days to bring this property into compliance. How long do you guys think you'll need? Please take in consideration this is a life safety issue right now.
And the life safety issue is of concern, and so that everyone is aware and can make an informed decision, the owner that is involved here has been embroiled in litigation with the association for a number of years. There have been multiple lawsuits that have been filed. This is a litigious owner. So gaining entry into the unit without his permission is plagued with pitfalls for the association, as they are afraid that it would once again result in a lawsuit being filed. We have an engineer, the same engineer that was available in May, has said that he will make himself available next week if the owner will just grant access for him to review exactly what these issues are as far as the structural issues are related.
All right, so Mr.
Again, this
McDowell,
has to be done, yes.
okay, we completely understand. Unfortunately, at this point, all we can do is assess that it is a violation and give enough time to come into compliance. And we do understand that now you have a civil issue between the owner and the HOA and the owner of the unit. So how long does the association think they will need to bring this property into compliance?
And may I ask a question? As far as bring into compliance, is the compliance just obtaining the structural report, or is compliance obtaining the report and making all of the repairs?
According
Because
to the compliance
unfortunately,
schedule,
without knowing,
do you have a copy of the compliance schedule? Have you been provided that by the HOA?
the compliance schedule, yes, I have.
It should state very clearly what the officer is requesting, which in this case, I'm guessing Officer Simmons is going to be full compliance, meaning obtain permits.
It says provide documentation from a certified licensed structural engineer that the existing structural members are sound and capable of bearing imposed loads, subwalls, or repair, replace, and paint where needed.
Correct, with a permit.
Right. So we have to gain access. We don't know exactly what the issues are without a structural report. So it's very difficult for me to give a time frame without knowing what the underlying cause or what a scope of repair would be.
I understand.
So
Fortunately, the board will issue a date. So we're giving you the opportunity to tell us, do you think you need 3 months, 4 months?
Dang, what I did?
Or Joe, you need to mute your mic.
Oh, I'm sorry. I'm so sorry.
Thank you.
Mr. McDowell, I have a question for you, if it's okay.
Yes.
Is there a way to somehow assign these fines directly to one owner let's say it's $250 a day and you do not meet your compliance date, is there a way to assess these to the owner and not the association in general?
Mark, are you asking the attorney?
Yes.
All right.
We don't assess, we assess to the property owner, which in this case is the HOA. That's between the HOA and the property or the unit owner to figure out.
I get that, but that enters into the amount of fines you want to charge, in my opinion, because if one person's being a real, pain over there, and we assign a huge fine, and he ends up not paying the whole fine, I don't think it's fair to the rest of the HOA, in my opinion. So that's why I want to see if they have a way to assess that back to the single owner who's causing the problem.
Yeah, I hear you, but I don't think that has any way on our decision, though. That's a civil matter between them.
So the association to operate in Florida is a not-for-profit, so any fines that are levied will have to be assessed against all owners for the bad acts of one owner. So that's one of the issues here, and why we would also beg leniency here if we are unable to obtain entry, short of filing a lawsuit to obtain entry, which is a possibility. It would have to go through the Division of Business and Professional Responsibility, the DBPR, mandatory arbitration, to gain entry into this unit, which also takes quite amount of time.
Yeah.
All right, for the sake of time, any other questions for the respondents? I'm not hearing anything, so I'm going to close for public comment and open it for final discussion and motion. Any thoughts from the rest of the board members? Aixa, Mark, Stephen, Joe, Diana?
Okay, this is Aixa. This is a tough case because it appears that the homeowner association is attempting to get this matter addressed and resolved, but there's other extenuating circumstances. And it's been an ongoing problem, and even the lawyer acknowledges that there's been issues with the owner. A time frame, my big concern is the life safety issue. I don't know legally what can be done to enforce it, condemning the property if that were the case, but first an engineer would have to assess it. I just don't know. A time frame, we can give the HOA months, but that may not be enough to resolve the problem, and there's still the problem of it caving in on the tenant or the homeowner on the unit below. I don't know what to tell you. I don't know what a good answer would be.
Yeah, I agree. It's kind of a stalemate with the single tenant there. It seems like with all this legal wrangling, any solution will take months, or more months than it already has. Like I said earlier, I hate to assess a big fine to an association that everybody's going to end up paying for one person. I realize that that's their problem that they have to work on internally, but it just causes more attorneys' fees and lengthy court cases and all that.
Yeah,
But
there's definitely not
I
an
guess
easy
we need to
solution.
have some kind of motivation to get this thing resolved. So
If it were to be condemned, I'd assume the tenant would have to vacate then. At which point would that help?
Well, in this case, the tenant is the owner, so.
Oh, well, even so.
Yeah, we'll be leaving him homeless. Although, it is a life and safety issue.
That's the whole thing. I mean, okay, if it is a life and safety issue and we don't want to condemn him, well, all right. If we don't want to condemn him because we're in this pandemic and it's not safe, yada, 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 but he's living in a spot that's a life safety issue, why not get him out of there? He's not safe in there either. So I guess,
But
I don't know. To me, that seems like, because I agree with Mark, it seems stupid to make the other members of the HOA responsible for this one guy's
Well, I mean, that was just a recommendation by the city. We don't have to go with the 250 either. The board can make a different recommendation when it comes to the fine.
Just hearing from the attorney, it sounds like no matter what happens, the gentleman who's really the issue, who we can't single out because of their legal structure, how do we get him to play ball? Or I guess do we just find guilt and make the associate make it their problem? I mean, I don't know.
Yeah, unfortunately, all we can decide here as a board is there a violation? Is there not a violation? Adjudicate and give enough time to comply. There's a lot of extenuating circumstances that are taking play into this case, but unfortunately that's out of the board's jurisdiction.
Well, I think in that case, there's clearly guilt. So I guess we need to find guilt, and then I suppose we need to come up with some type of timing and fine structure that we think would get to the direction we want to get, right? Mm-hmm. So what would that be? I mean, should we do less money, more time, vice versa?
One of the, this is like, so one of the concerns I have is if this thing caves in, I mean, obviously if it's a life safety, until the structural engineer comes in and addresses this, there's not a whole lot that can be done. I mean, there are, if the gentleman has some mental health issues, but that would be a court matter. That has nothing to do with us. The concern still is, like you, Steve, I feel that we're punishing the HOA on a matter and the rest of the homeowners on a matter that is limited to one individual.
I have a question real quick. Now, we have only been addressing the unit that obviously is the one that officer inspected, but have you been to the unit downstairs and see what the condition is to that unit? Maybe the engineer can assess the damage or can assess the structural condition by visiting the downstairs unit?
I have not visited the downstairs unit, but when I spoke with the engineers here at the city, they stated that someone's going to need to go in there and they may have to rip the whole floor apart and figure out what's going on underneath.
But that can be, but Officer Simmons, that can also be done from the floor below. They'd have to tear out all the ceiling.
The ceiling in this case.
And then of course the HOA would then have to either agree to repair that. And that would be another way of perhaps addressing the matter without going directly through the gentleman, you know, through the tenant and through the homeowner.
Mr. McDowell or Ms. Eva, has anyone made contact with the downstairs unit occupant?
Can you hear me?
Yes, we can.
Okay, yes, I did. I spoke with the resident of the unit below, and I also spoke on the phone with the engineer, and he told me that it would be hard for him to identify the damage from the unit below unless, as you're saying, he removed the whole ceiling and have access. That the best way is for him to inspect this particular unit, because he said that just looking at how the windows frames are and the doors frames are, he can determine if there's any structural damage on the floor. So,
well, I mean, the floor of the unit upstairs is the ceiling of the unit downstairs. So either way, he should be able to access the same foundation. So even if he goes from the bottom up, we're still accessing the same damage.
That's what I understood. That's what I thought. But he told me that as an engineer, he would need to have access on the unit above. I can try to him. I don't have no issues. He's just waiting for me to say, go and check. So if I ask him to go to the unit below, he's willing to go. You know, I have everything ready as soon as I have access to the unit upstairs, or if we have to go through the unit downstairs, I'm willing to go that route too.
Okay, thank you. So from what I'm hearing, we should be able to access the damage from a different angle. So the association should be able to at least get some information as to far as the structural condition of this unit, and then they can move in a civil matter, whichever way they want to, you know, if they have to have litigation, if they have to have evictions, whatever they need to do. So they have an option. They can come in from downstairs and assess the damage. These are termites, so it's not like the termites are going to determine this is upstairs, downstairs. They're going to continue traveling through the different units. So I think we just need to come up with a deadline, a compliance date. And if we want to evaluate the fine, we can do that as well.
Ms.
Fair.
Simmons, what was the time that you were originally giving them?
30 and 250.
Mm.
I'm
And-
leaning towards maybe, I don't know, maybe, what does the board think? Maybe 60, between 60 and 90 days, and maybe reduce that fine a little bit if that is a concern.
I was thinking about, yeah, maybe 90 days. So we can probably do 150.
What is the
I
board think?
was thinking 90 and perhaps dropping it down to about 50 or 100.
Yeah,
And
that's what I was thinking, 90 and 50.
only because there is, it's a legal matter. I mean, it's a, you know, two opposing legal conditions. And so that's what I'm thinking.
All right, so let's make a motion.
Based on the evidence. All right, ready. Based on the evidence I've seen and the testimony I've heard, I've moved to find the respondent guilty of the violations as stated on the compliance schedule submitted by Officer Simmons.
Second.
Motion has been made and second by Stephen. All
Yeah.
those in favor?
Aye.
Anybody opposed? With no opposition, motion passes.
Further move to give the respondent 90 days or until October 6, 2020 to bring the property into compliance, or a penalty of, did we say $50 will be imposed?
Yeah.
And will continue for each and every day of noncompliance. And in the case of noncompliance, we authorize the city attorney to begin lien and foreclosure proceedings.
Second, Steve Simpson.
Motion has been made and second. All those in favor?
Aye.
Anybody opposes? With no opposition, motion passes. All right, Ms. Eva and Mr. McDowell, the board has given you 90 days to bring the property into compliance, or $50 fine after that. We recommend, strongly recommend, please stay in contact with Ms. Simmons with the progress of this property.
And this is Mr. McDowell. If I could just clarify with the panel, there were two apparently separate issues here, and I'm afraid they have been confused. One is termite regarding dry wood, and one is with regard to concrete flooring.
Both of those were addressed on the same compliance schedule.
Yes, so and I know that we discussed the concrete flooring, which is a potential life safety issue. For the termite issue, before code compliance even came to assess, Massey was at the property in January 2020 and
Mr.
said that they
McDowell,
believe.
I'm
Yes.
sorry, but the case has already been heard and closed, and a compliance has been established, a motion.
Okay, I just wanted to make sure that we weren't mixing the termite issue with the structural issue because they were separate, that's all.
No, it was all addressed under the same compliance, under the same case.
Thank you.
Thank you. All right. I'm debating between taking a quick 15-minute break